Welcome. This is the Domain Name Law Show. We're here every Tuesday, noon Pacific, 3 p.m. Eastern. This is our first show of 2026. We thank you for being here and thank you if you're listening on replay. I'm one of your hosts, Todd Ryan. There's three of us, David Michaels and Jeff Neuman. I'd like to always say hi to my co-hosts as we get rolling here today. Hi, David. How's everything going? Let's do a mic check.
Pretty good.
Sounds good. Sounds good where you're at. Hey, let's see if we got Jeff. Jeff, are you on stage? It doesn't look like it to me, but you surely could be. You there, Jeff?
I am here. Yes, it's great. I thought you were talking to David, but
I was.
I'm here. I'm excited to be back, and Happy New Year, everyone.
Yeah, Jeff, it's nice to have you. I see it just was just showing me as listener at first, so this thing's a little delayed. But yeah, I'm looking forward to, well, I'll be seeing you next week at the ICA Meetup. Um, Arif, if you're going, put a thumbs up. I know David's not going to make it, but he's a member. We're going to talk briefly about that, but I guess Arif's not. I don't see a thumbs up. Um, but yeah, I look forward to getting back with colleagues face to face. But there's quite a bit of news and things going on. I see Arif's not going to make it in the space. Okay, you guys know on Thursday I do the room with Josh, and we're launching this week. So a lot of the domain investing topics or domain industry news, I'm leaving it for that show because we go 2 hours there. Here we try to stay just on the legal topics, and I'll mention that. So if you're listening on replay, we normally go through domain industry legal news, and then we might touch on a few other things, but then we jump into, normally it's domain disputes, UDRP decisions. Sometimes it will be some court cases. Um, Today I wanted to mention, well, there's some cases I didn't put on the outline that I thought were interesting that I just read about, so I might touch on. One was just off of Domain Gang, and I want to shout out to Domain Gang. I didn't get a chance to meet Theo in Miami, and I certainly wanted to. He's somebody I've always, read Domain Gang. I like Domain Gang. If you haven't been to that site, go to domaingang.com. But he had a couple interesting articles. One I put on the outline at the last minute, guys. I'm telling my co-hosts because something I just wanted to make sure there was a link to. So when I mention it, folks might be interested in it if you're listening. Like I said, on live or on replay. But there's actually a contest that he brought to my attention. I could put direct the Namecheap link, but since I saw it on Domain Gang, I wanted to put the Domain Gang link on our outline, and our outline is at dnlshow.com/outline. And Namecheap announced a $10,000 contest for small businesses here in the U.S. Basically, they're giving away 10 grand, 5 grand, and 1 grand. I put the link on our outline. That's at dnlshow.com/outline. Or you can just go to Domain Gang, and they have the Namecheap link. I thought it was pretty interesting. Basically, if you got a small business, and you, even if you haven't set up your LLC yet, they're going to help you do that basically for free, other than a state filing cost wherever you're at, because they got this Namecheap business starter kit, and it includes a domain name and hosting and all sorts of stuff. But basically, they're just trying to, they want you to send in what's your business story, what are you doing to make it happen, basically how are you executing your vision, and explain how getting a few bucks, a grand, 5 grand, or 10 grand would help you meet your goals. And they're just going to have an internal panel, decide in May. So the contest goes from today to March 22nd. As I mentioned, check it out on domaingang.com. It's one of his most recent articles. Namecheap announces $10,000 contest. Or you can go to our outline, dnlshow.com/outline. I have an idea that I don't, that I'd love, that I might submit there just because of so many ideas. And anyway, I think it's a nice thing that they're offering at Namecheap. Um, Before we get rolling, I wanted to ask, so you've had a busy start to your year, Jeff. Tell us a little bit about, how the last year finished up for you, and what you're working on, if anything you can share. You're going into 2026.
Yeah, I mean, last year ended really busy and this year began pretty busy. Um, we're I had a couple UDRP decisions. I think one of them we'll talk a little bit about later. And still working on a bunch of litigation. The the one that most people know about, the GoDaddy one, that's still ongoing. It's in discovery, so lots of all I'll say is just lots of motions practice going on. Um, so that it's and this is going to be a busy year for that one. Um, yeah, and just a whole bunch of other things. People gearing up to file for new TLDs in a few months. The applicant guidebook, which is kind of the RFP document, was approved at the end of well, it was approved in October, but it was finally published in the end of December, just before the break. So that's out there now. And so, it's crunch time for those that do want to apply, and encourage those to look at the outline for some links on there to go to if you're interested. And Todd, of course, is my partner in that. And so looking forward to doing that work along with everything else that's going on.
This is certainly no doubt going to be a busy year for you, Jeff, with the next round, with you taking on, it seems like more and more cases as a panelist. And I know that's really a job. It's not, certainly not a primary way that you get paid, but it does take up your time. And I know that's important to you, and all the work that you do related to ICANN that's not, um, say, the new GTLD related, and then of course your practice. So this is going to be, I know, a very busy year for you. About the applicant guidebook, that is something that we're probably going to touch on. I think we might do it after ICA. I was going to put it on the outline for next week, but I think next week we'll have a smooth week. We'll just review some cases, and then we'll talk about the applicant guidebook. And as Jeff said, it's really crunch time. If you are applying for a GTLD and ICANN's next round, or you're just, still thinking about it, you can, it's time to make some decisions, and we'd be happy to help. As Jeff mentioned, at tldstrategies.com, you can set up a meeting with Jeff and I, and we'll let you know how we can assist in whatever you plan on doing with it the next round. Applying, basically acquiring a string and then managing it afterwards. And we help you, we call it a one-stop, start to finish. And that means there's really no finish once if you're successful, and we think we can help you be successful in acquiring an extension, a string. Then the work starts with becoming a registry, all the complying you need to do with ICANN, but then really operating a successful registry. That's when the work begins. So once again, reach out to us, tldstrategies.com. If you're in, especially, for those, say, listening on replay, you might have some folks in mind that are helping you for one string. If you're applying for multiple strings, you might want to have different folks help you for different strings, and we can tell you why that may be beneficial if you want to have a free consultation with us. But also, I'd like to compare. Okay, so they're offering the service, to assist you. What are the fees? What do they offer? And we like to show that we think we're the right fit for most applicants. Okay, I did want to get to, so if you have any, if you're looking for someone to help you with a domain dispute, you certainly want to reach out to Jeff. You can always reach out to the show, and then I direct you to, meaning I'm going to direct you to Jeff. But if you're looking for some trademark help, I might direct you to David. So I want to get to David and say, David, tell us a little bit about how your 2025 finished in a couple areas. One, your business, meaning helping folks with their intellectual property needs and trademark needs and so on, and then your domain investing year, and then what you're looking forward to in 2026.
So I've been mostly focusing on trademark searches, doing in-depth searches for clients that cost a lot of money. I'm trying to figure out how to automate a lot of that, and also doing some consulting. Like, is this brand any good for you? Can you get it registered? Uh, and creating tools that will actually help clients, do some self-service so that they can do that on their own, and it's a lead generation system. Yeah, so 2026 is going to be a lot about building AI-powered apps, especially for managing trademark portfolios. I think that's the biggest problem most lawyers have. They can file their own responses and stuff like that, but just knowing what's up next and managing it all is a big problem for many lawyers and many businesses. So that's my big project for 2026.
Great, thanks for sharing. We're, as I mentioned, if you have any domain dispute needs or you're looking for an attorney to help you, you can go to dnlshow.com and click on, we have an attorney list, and it really is the top lawyers in the domain space. And as I always mention, domain law is its own niche, and you really, if you have a domain dispute, you need an expert, an attorney that knows domain law, because we see more and more of these UDRPs. Big firms, well-known firms, prestigious firms file complaints, and they're really flimsy, basically not smart complaints. And now it seems to me some panelists are wising up to it and really holding some of the bigger firms, feet to the fire, saying, "Hey, listen, if you're not even filing this appropriately and including basically what needs to be included." My point is, if you have a domain dispute, contact an attorney that understands domain disputes. It is a specialty. One of the articles I was reading on Domain Gang, I wanted to mention it quickly, and then we're going to get to what's on our outline. And like I said, our outline's at dnlshow.com/outline. There was a case that I thought was interesting. We may touch on it next week. cmocoaches.com. It's a domain name that was stolen, and it was stolen from a domain owner. Then this domain owner ended up filing a UDRP to get the domain back, and he was successful. And he was represented by a friend of the show. I say that, John's here, John Berryhill. And it's an interesting case. I haven't really looked at it, only I just saw as I was looking at Domain Gang today that they mentioned that it was successful. And I know we don't see a lot of, or at least I don't come across a lot of cases like this where you're filing a UDRP to get back a stolen domain name. I don't know if, I'm going to do this at my own risk. It is John. I was going to invite John to speak real fast if he's able to say how frequent this happens, and then we may go over this next week, but how frequent it happens when a domain is stolen and then someone files a UDRP to get it back, because it is, a bit unusual. So that's CMO Coaches. Interesting case. Anyway, if John, as we're going on today, I know you may stick around, may not. If you may want to make any comments on some of the cases we're going to talk about, you're welcome as well. Look forward to seeing you next week too in Vegas. Hey, so there was a case, Jeff, a couple weeks ago that we went through, and it was your case, letslucky-play.com. So this was, we're just going to touch on it today because we went through it a couple weeks ago. David had some questions on it, but I'm going to just let folks know, sort of summarize what happened. So this was a case, the domain name, it was several domain names. letslucky-play.com was one of them. letslucky-know.com was another one. But anyway, this complainant had this online site. They were on letslucky.com, but they noticed there was all sorts of domains that were registered with Let's Lucky in it, and they were recent registrations, and the respondent didn't reply. In this case, Jeff was the panelist. He ruled there to be a transfer in this case, but David had a few questions about it. But before we get to David's questions, David, I'll let you gather those. Jeff, tell us what you remember about the case, meaning really just some of the facts of the case, and was the case an easy transfer decision as it sort of appeared to me, or were there some nuances to it that I didn't notice?
Yeah, I mean, it, the biggest issue there was the determination that all of the respondents were the same, right? Because there's a rule that basically a UDRP can be filed against multiple domain names if you can show that it's the same respondent, or the same um, group together that's done it. Some kind of affiliation, right? Because of course the respondent may use different names, but if you could show that it's really the same entity or the part of the same scheme, that's the word I was looking for. Um, then you can proceed in the case. So for me, kind of going through all of the um, evidence that was submitted to try to loop all these respondents together as one, that for me was kind of the toughest. But ultimately, at the end of the day, there was enough there um, that essentially created at least a good faith, or at least more likely than not that they were somehow all related, just but all in different ways. Some related to similar websites, some related to similar um, not name servers, because those were Cloudflare, I think. I have to go back, and of course, many people share those, but um, there were similar attributes, and I'm trying to pull up the decision pretty quickly. But that for me was, once I got past that point, given the fact that the respondent never responded, just made everything sort of fall into place.
David, you had some good questions about this decision. And as I mentioned, so there was several names. The complainant's on Let's Lucky. It's a weird name, but it's good, I guess. Let'sLucky.com. And then this respondent registers all these names with Let's Lucky in it, and he doesn't respond to the UDRP. Jeff, it was the panelist, solo panelist here, rules that it was a transfer, and you had some questions about the decision. David, go ask Jeff.
Yeah, so the decisions that they were using the same registrar, but when I went through them all, I found that they were using different registrars and they were registered on different dates. Yes, they were all using Cloudflare because that's a standard in the industry. And yes, the websites probably look similar because there are basically 4 different white label solution providers for gambling sites that are like prominent anyway in the industry, that a lot of people will use for their affiliate programs. They like to scale these things. Usually, what people do, I haven't done this myself, but most people will buy an expired domain name that has juice in it, launch a white label website, maybe change the colors a little bit here or there, but the organization of it is pretty much set. There's very little you can change other than maybe some written content. And that would give the same kind of outline. Now, remember you mentioned in the decision something about the links, the affiliate links were not going to the complainant, but rather a competitor of the complainant. Um, that could be. Was it an aggregator? That's a question. I don't know if there was like a question mark and a code after that to substantiate whether or not it's the same affiliate account or a different affiliate account with the same provider, because there are aggregators that do that. So yeah, those were my questions. And yeah, I probably, when looking at this, just from what I see in the decision, I probably would not have aggregated them. I would probably say, okay, pick one, and the rest are not included. Um,
Yeah, like I said, the hardest part was seeing whether they were all related, and I only kind of summarized, or I tried as best I could to summarize all the different connections. I think I said at least 2 of the names use the same registrar. Um, but uh, yeah, I mean, look, there were a lot more than these connections, and that took me a long time to go through kind of the web of all the connections. The fact that there may be aggregators out there that have similar, you know, I don't know anything about that, right? And that's the party's obligation to bring that. There'd be no way for me to know that. extend it to a judge, let's say. Um, there's no way for them to know any of that stuff without someone bringing it to them. So the fact that no respondent responded to bring any of those arguments, they can't really be considered. They're not on its face things that you would know or could know. Um, there are other things that you could on its face know, like, when we talk through, and I think there's one decision today we'll talk through, which has um, affiliate links that were put up by the registrar as opposed to those that are put up by um, the registrant itself. Those, being in the industry, those things we could know offhand, but the specifics of the gambling industry, no way for me to know that without having someone bring forth that evidence. I don't really have an answer for you on that part of it. But it would have been a good point for the respondent to bring up if it um, A, didn't own all of those names, and B, if it only owned some of those names, it would say that. Um, looking at this again, it was the close call was whether these were all one um, respondent. But after we found that, it just seemed like there was too much evidence there to um, find anything other than they were being used in bad faith.
When who sends out the complaints? Is it the registrar? Sorry, the ADR provider forum, or is it the complainant's lawyers?
Um, well, by rule, it's the forum or the dispute provider, WIPO if it's WIPO. Um, but sometimes I've seen complainants send it out where they actually know who the respondent is, right? In most of these cases, um, the respondent um, only gets the information, or sorry, the complainant only gets the information about the respondent once it's verified by the dispute provider, and the dispute provider, gives complainants the opportunity to amend, which not all do. And even if they amend it, I'm sure most complainants at that point don't send it to the respondent, but let the ADR provider take care of it.
That's something I'm
Yeah,
going
so
to.
does ADR provide you with like a list of like all the emails they sent out, like were all these supposed entities or individuals notified or not? How do you know? Like, how do you call that? How do you
Yeah,
know
so
that or not?
so yes, the verification emails sent to the registrars indicate the different contacts for each of the names. And then, yes, as part of the file that we get, we get emails of the transmittal of the complaints to each of those email addresses.
Cool. All right. Well, hopefully next time they respond and say, "Hey, I have nothing to do with those other guys." But I think
Yeah,
those
no,
names are like really low value, so it's
right.
crazy that they would even do this.
Yeah. So if that were the case, yeah, and any other respondents would have responded and said we're not at all related to the others, um, then yes, I would have gone to the complainant and say, pick one, like you said, or pick, maybe two of them that are the same. Who knows? Whatever. But in this case, nobody did respond.
And I think this is it's a fairly interesting point. So you're a domain owner, and for all of you listening here, when someone files a complaint against a domain, most domains have privacy on them, or at least some sort of privacy. So as Jeff mentioned, you file a complaint, this complainant, it goes, you file it through WIPO, you file it through the forum, and then the forum, what they do is they contact the registrar, and the registrar says, yes, that domain is here at our registrar, and here is that when they give, how much information do they give about the registrant then, Jeff? So say it's like, they file a complaint, I have privacy on, or that little bit of privacy, whatever is included in the basic registration. Then does the registrar give all the information that they have, basically the name, address, phone number, and email address of the actual, basically the information underneath the who is, or underneath the privacy?
Yeah, that's it. It's all the information that's under the privacy, with the exception of technically in thick registries you still have fields for billing contact, but I don't think those are really provided anymore. But it's really just the registrant contact information. So I can't recall. I'd have to look real quick to see if you get the admin and the technical. I think it's just the registrant contact information. Of course, you don't get things like credit card numbers or billing or any of that kind of stuff. It's the basics. It's email address, physical address, telephone number that they use in the registration, obviously the organization name, but that's it.
So the decision rights, the email address is all being postmaster at each domain name. Is that the real thing that they used, or is that just a placeholder? Because that's kind of wild, because most people don't have a postmaster address.
Yeah, so let's see, where that's in the decision. If that's in the decision that I
Yes.
wrote, and is that in the procedural beginning part, or is that in a separate place where I'm
It's in the
comparing?
beginning.
Oh, in the
It's the third paragraph after the procedural history heading.
yeah, I mean that must have been the yeah, that's the after the verification from the registrar. So it is the email addresses that are underneath the privacy or the redactions because of GDPR.
David, that makes it more likely that they probably are owned by the same person if they all put postmaster. So I'm following along, and I'm wanting everybody else to follow along. Bottom line is, you file a complaint. Or if you get one filed against you and you have privacy on, the registrar is going to say, okay, here's who's under the privacy, and then the complainant has a chance to refile, like Jeff said. And when you say refile, it just means now just take out or just add in the actual registrant's name, because when you first filed against that domain name, you might have just seen, nothing because it was under privacy. So now you have a chance to refile. As Jeff mentioned, many of the complainants don't refile. And Jeff, just so I'm clear, why would it benefit a complainant to refile, and why in most cases don't they?
Well, when they do, it benefits them because maybe they've done some research. Now that they have the registrant name, they may be able to tie it to other registrations. They may be, or previous UDRPs. Maybe, when they're researching it, now they really know that they have no connection to this domain, right? They have no bona fide they're not commonly known as the domain name. So the people that do respond, it's usually because they find something out that adds to their evidence of the second or third element.
It makes a lot of sense. No, and thanks. And that's really someone being a complainant being more thorough would likely do additional research, but also, like you said, amend, refile with the person's name. It seems like it can only really benefit them. And what David was, I'm speaking for David, what David was getting at, that he and I both find always important, is the service. How are they notified? And you mentioned, okay, so once the registrar says, here's the information, here's the registrant name, and here's the their email address. Of course, the service provider sends out, here's a complaint that's been made against you, and sends it to that email address. But I think if a complainant is doing research and they find out, okay, so here's who it is, they might find other emails that are maybe more active. The one that's on your registration may be something that you used several years ago when you registered the name, or you put on a one that's no longer good. And then I can understand a complainant basically, reaching out to maybe another email address that they found on, that from that domain owner, and see if they get a response anyway. It may be something they can use in the UDRP if they had to file amended, something amended to say, hey, we did get a response from this email address. But the point is, these respondents, you really do need to respond. I'm always on the side of the domain owner saying, did they really get served? Did they really receive an email? And did they think it was a legitimate email? Because you wonder, why are so many not responding? That said, a lot of the non-responses are still being, a lot of the decisions in these no response cases are still being thoroughly thought out by the panelists, because panelists are, it's not that they're not requiring it. Of course, they love to get a response from the domain owner, from the respondent. But as you're going to see in these upcoming cases we're going to talk about today, respondent didn't reply in some of these cases, and the panelists still made sure that the complainant had a good case, a successful case. You don't just, always, rule in the favor of the complainant when there's a no response. And of course, we know that. Before we get into our first case, there was just a quick story. Ping.bot was a UDRP that I see the complainant was this company, Ping, the one that makes these golf clubs and golf equipment, and they're on Ping.com, and they went after Ping.bot because they just really like to control anything with Ping in it. And the complainant in that case is just a news case, was saying, hey, there's PPC links on that page, there's some golf stuff, and that's why we believe that we should, this site should come down and it should be transferred to us. But the respondent the domain owner did respond in that case and said, listen, ping is a term used in, computers and all sorts of, I don't know, they used to own Ping.site, and he said he dropped it because it was $3,000 renewal. Ping.bot is only $1,000 renewal. And basically the panelists in that case said, yeah, this person has a legitimate reason for to buy Ping.bot, going to build a business on it, and made basically what they mentioned about the renewal rates just struck a nerve with the panelists, meaning the panelists said, yeah, it makes sense. I can understand not wanting to spend $3,000 trying to find another option, and ping is a generic term. You guys read anything about that? I put it on the outline, but any comments on that?
Yeah, I thought that was really interesting. And a lot of the cases today, I kind of had to go back and reread the facts several times because of how complicated it just seemed through the first read. I don't think this was one of them, but the other ones certainly were. This one, and I know the attorneys at for the complainant, and I know how aggressive they are. Um, this was a close call as to reverse domain name hijacking, and that surprises me because of the caliber of attorneys that I know that work at Elster and McGrady. Um, so that was a little surprising to me. But at the end of the day, there was just too much evidence there where the complaint shouldn't have been filed, or this could have been a case where there was no information known about the respondent, of course, because of what we were talking about. The privacy redactions and things. But this could have or should have been a case where once they got the name, um, they, and maybe were able to find out a little bit more, that they might have considered withdrawing it. But the forum really doesn't give you an incentive to withdraw the case because they don't refund you any fees. WIPO will if a complainant withdraws before it goes to a panel, but the forum doesn't. So the incentive is really, even if I'm going to lose, I might as well just keep it there, as opposed to withdrawing because I've already lost the money. I think that's terrible. I think that needs to change, but that's one of many things I think that need to change. Because at the end of the day, this, ping um, is like you said, it's a descript or generic type term for other things, and you can see that all over. And in fact, this kind of dispute came up when I believe it was, I can't remember if it was Radix or XYZ someone applied for I think it was Radix that applied for .ping, Ping, and they got for the TLD, and they got an objection filed by Karsten, by these the golf company, and they lost. The golf company lost that objection pretty much because of the same types of things, that it's a you can't say that the TLD will only be used to infringe the trademark rights of Karsten, the complainant. And so they lost that case too. So it just kind of made me think about that when Karsten opposed the GTLD application in 2012. So it is a TLD out there. I think. I think it was launched. I have to double check now.
Yeah, David, did you have a comment on this?
Yeah, Ping is registered in 303 TLDs according to .db. That's a lot. Why are they filing these UDRP complaints against SLDs with the word ping in it? That's crazy. Like, the biggest competitor this guy has can be Pingdom, which is now owned by SolarWinds. Pinging, on the internet is a huge industry. So I don't know why this golf company thinks that Ping.bot is meaningful to them, unless maybe they want a bot to carry the golf clubs called Ping. That's the only thing I can think of.
So I just did some research too. So Ping lost the company, sorry, Karsten, lost the objection for .ping, but then entered into some kind of deal, I guess, to purchase from Radix the .ping registry, and now it's a brand TLD. It's not used. It just, if you go to, well, is it used? Hold on. I mean, it's got a nick.ping, but it's not used. Doesn't look like there's any live sites other than Nick. Um, but yeah, they did lose the objection, but they must have purchased it for an undisclosed amount.
Very wealthy company. And David, what you were mentioning is, yeah, are they going to try to do something with Ping.bot? Probably just their attorneys, people trying to say, let's be defensive, just like with the .ping. Well, they bought it from Radix. For what reason? If they're not using it even maybe internally, it's just like they get sold. Some of these companies, we don't know if this is one, but get sold on just be defensive, make sure nobody else can, start using that extension or that term too often, because we want them to think, when they think ping, only think of us, this golf equipment company. But we know everybody says ping me. I mean, I deal with Chad says it to me a lot. Ping. Something about ping. I don't know. I think so. Definitely sync. He uses the word sync. Let's sync on Friday. But anyway, so right, Ping is sort of a heavy-handed company, that golf equipment company. I see aren't afraid to file UDRPs and lawsuits to protect their brand. All right, there's 3 cases today. I think you guys in the audience and listening on replay are going to find them interesting. I agree, Jeff. I select these cases. Because primarily the domain name, and then I look at the facts and I think, geez, there's several things here that I'm sure Jeff and David are be able to pick apart, and that I try to look at. But anyway, the first case today is for a domain, reboost.com, reboost.com. As a domain investor, we're thinking reboost, okay, 7-letter name, looks pretty good. The complainant in this case, Select Inc., Seelect Inc. versus Gilad Tisona. Okay, so this was a U.S. company versus this U.K. individual. But the complainant offers these powdered isotonic sports drinks. It's really just powdered drinks, but isotonic sports. I think isotonic have something to do with muscles, I guess. But anyway, they offer this powdered sports drink under the name Reboost. Okay, they've owned a trademark registration to it. Looks like since 2009, from what I see. David, if you want to correct me there, I don't know if that was just their common law mark or when they finally had it registered. But the domain name reboost.com resolved to a site with health supplement gummies, at the time of this filing. So in my opinion, health supplement, that's a powdered sports drink that the complainant offers. This is a health supplement gummy. The complainant felt like it's too close for comfort to their product, to their trademark. So they filed this, and they actually said, we got the registration, I think, in 2009, but we've been offering this product since 2008. And the complainant went through their normal thing, because in this case, I didn't mention yet, but the respondent did not reply. The complainant went through their normal. They are not known by this name, which sound to me like they are a little bit. The respondent has no legitimate use and only put up this site, recently in 2024. Before that, the respondent didn't even use the website at all and didn't show any preparation to use the website. So we believe that they have, got this name just to make money off of our trademark. Okay, so I'm going to leave it at that. There was a solar emitter panelist. Jeff, I'll let you go first. Sounds like you read into this case a little bit. You tell us what you think of the facts, add what you will, the story, and then David, you chime in after that. Thanks, guys.
Yeah, this one wasn't, the facts wasn't as complicated, I think, as the next two. But at the end of the day, what surprised me, the interesting thing here, is that, yeah, as you said, there was no response, but the panelist decided to do her own research, um, and not just like normal research, like, looking at the site, which, of course, is something every panelist should do. But she went out and did a search for the respondent's name in a search engine, not the name Reboost, but the actual, I think her name, oh, I'm looking at it now, Jalad Tisona. And they found out that respondent was associated with a company called Healthy, Helfy Limited, and that the the respondent, Jalad Tisona, is its CEO. And then she did a further search under that name to reveal that there was a trademark registered in the EU by the Healthy, Helfo, Healthy company for Reboost. That was registered on 2022. So it was after the complainant had registered their trademark, but it was still a registered trademark in the EU. And I think, and the panelists did the right thing here. When you do your own research, that's extraordinary. Not just looking at the website, but doing these kinds of searches. Panelists did the right thing here. She issued a procedural order to the complainant saying, "Hey, I did this research. I found this out. You want to change your complaint, add other evidence? Do you have any response to what I found?" And the complainant apparently just responded saying, "No, that information doesn't really alter our case, and go forward." And the panelists said, "Well, okay," and ultimately found out, essentially that although they found the first element, which again is just a standing requirement, of course, reboost.com looks like the trademark, or is confusingly similar to the trademark Reboost. But with the second element, whether there's rights or legitimate interests, given the panelist's independent findings, the panelists basically said, I can't tell, or I should say it this way, the complainant hasn't demonstrated that the respondent doesn't have legitimate interests, or that they used it in bad faith. And because this is not, looking at the website, it doesn't look like impersonation or, any kind of counterfeiting of products going on. It resembles more of a trademark infringement action, if anything, between two owners of trademarks, and ultimately found the right thing, which is that this is beyond the scope of what the UDRP was created for, and that at this point, the complaint has to be rejected. And she found in favor of the non-responding respondent in this case. So, Yeah, again, real interest. It's the right decision. The real interesting thing is the fact she did this research, which I would say 70% at least of panelists would never do that kind of research.
Well, good thing they did. But in this case, the trademark that she pulled up was actually the EU IPO mark for health services, which is part of the Happy company. But the Reboost company is reboost.com is actually resolving in German, and it's a German website selling gummies. So is that legitimate? Probably, because U.S. trademarks don't have any impact abroad. Like if somebody wants to sell Reboost stuff with the exact same logo and it's owned by the same company, then I think that's fine. I think there should have been an RDNH in this case.
Well, David, you say it's good that they did about the research. Yeah, good for the non-responding respondent, but obviously not good for the complainant. This is a classic case of a complainant normally makes their prima facie case, and then when there's no answer, like Jeff said, the majority of panelists are not going to do this research. And I hate to say that the panelists tilted the scale in favor of the respondent, but really did, because some panelists would say, as much if the respondent would have responded and said, we have an EU trademark and our color scheme is different, we're not impersonating, then it makes sense that a panelist could have ruled for the domain owner. In this case, all those things that Jeff mentioned about no impersonation, the website was different, there actually was an EU trademark. This was all found out by the panelist through their research. So in most cases, that's not going to be found out. It's definitely evaluated if it's submitted as evidence by the respondent, but this respondent didn't do it. So really, all this stuff, all this evidence was just found by the panelist in their own research and then used against the complainant. Basically just the panelist said the complainant's case is not that strong from what from what I've learned about this respondent. So yeah, I like it as for a domain owner that you get a panelist like Gabriella Kennedy. But if this would have been many panelists that we know, some good, some bias towards the complainants, I think, but even some good panelists that I know wouldn't have done research like this and probably would have transferred the name because of the complainant made a case. There's no response to it, so I'm going to go ahead and say that it will believe what they've had to say when there's no refuting it. So yeah, interesting. Well, before we get on to our next case, so reboost.com, the complaint was denied. The respondent did not respond, but was allowed to keep the domain name, so it was ruled in their favor. Hey, Arif, thanks for joining us. It's nice to have you here. What's going on? Any comments or questions? What's up?
Hey guys, Happy New Year's. Hope you guys had good holidays and whatnot. Wishing you all the best for 2026. Yeah, I just had a couple of questions about the ping thing, and then I wanted just a couple of things about the ICA. So I can wait till the end. I'll let you guys finish these cases now that I've already started with them, and I can just come back to the questions at the end if you want. That's
No,
easier.
great. Then that way, thank you. And that way we can make sure we get through these, and then we'll certainly get to you if there's add
Sounds
on
good.
anything else that you can add on. Like as you hear these next two cases, then we'll cover it all here at the end. Okay, the next case, upkeeping.com. When I look at this name like upkeep, we know, I have I have a farm, got to upkeep it, and everybody's got homes, everybody's got basically, there's upkeep is a pretty popular word, I think. Upkeeping, weird as a domainer because um, what do they call those when it's got the ing on the end? It's not a gerund. What is that called? What is it?
Yeah, Jerome.
Oh, it is a gerund. Okay, but upkeeping. So as domainers, you know, that is a single word, but we wonder, how valuable. Well, I think it's interesting because this was the disputed domain, upkeeping.com. Upkeeping LLC out of New York was the complainant in this case, and they were going after this company, or going after an individual, Andrew Klein, who ran a company, Z Counting. It's like Z Accounting, but Z Counting in place of the A, I believe, was their website, Z Counting. Well, so the complainant is in the bookkeeping business, really. So is the respondent, because we find out this is just a a convoluted case. I'm going to say one thing and then pass it to you, Jeff, and then David, once again, you chime in after Jeff on this one. But this case, there was a relationship between the complainant and the respondent. The complainant once worked for the respondent, left, and then said, I'm starting my own thing called upkeeping, and was doing it on, basically didn't want to buy the domain name. I believe it was $7,500. And I think you're starting a business, but then again, it was, small bookkeeping operation. The person didn't want to spend 7,500 on the domain name, so they went ahead and bought upkeeping.co through GoDaddy. When I say bought, it sounds like they registered upkeeping.co. Okay, then what they do is after they registered upkeeping.co, they get an email from DAZ, DAAZ, that company that said, hey, when you had inquired about upkeeping.com a few weeks back, and we know you didn't purchase it. It was priced at $7,500. We just wanted to let you know the offer that you made, everything's canceled because this name has sold, in fact. Okay, somebody did buy it, and it's no longer for sale. So we just wanted to let you know. And then that complainant thought, geez, that's, I wonder who bought it. Went and looked at the website and said, oh, they're copying what I'm doing, and found out that the new owner of upkeeping.com was this person she used to work with, or he used to work with. I don't know. So I believe it was a woman, because it was Erin, Erin, because what the complainant says in this case, and I'm almost done here, is hey, this guy I used to work with, now I'm doing my own thing. He knew I wanted to do it on upkeeping because he saw my upkeeping.com, ended up buying upkeeping.com and created a fake email address, but basically was trying to take business from me, impersonating me. And then, of course, the respondent in this case did respond and said, yeah, she took business from me, and it was sort of that type of dispute. Yet Alan Limberry still decided to make a decision in this case. So now I'm going to throw it to you, Jeff, and talk about the unusual facts in this case, and then Alan's decision, and then David, tell us what you think about Alan's decision here.
Yeah, so the respondent didn't submit a formal response, but submitted two informal emails basically saying, or one was just asking some procedural questions, I don't know what, but, and then said, well, the complainant was previously my employee, and therefore she took some of my clients and this name, or she went, we were the ones essentially, I guess, that came up with this name. It kind of raises, an issue like, because she used to work for the respondent, was it really the respondent that came up with the idea of using upkeeping.com? And then she went and tried to get it for herself. But we'll never know because the respondent didn't really reply with any more facts. But, so the rest of this decision is kind of looking through the eyes of the complainant, where I think it really could have been a lot more interesting if the respondent said, wait a minute, she worked for me part-time. Anything she did for me as the employer is my intellectual property, and she went and stole this name from, we told her we were going to get this name, we got the name, but she stole the name from us. Yeah, she didn't get the .com, we ended up getting it, but she got the .co. That's not what happened here, but that would have been very interesting. What happened here is the respondent, at least because it didn't submit more of a response, we sort of have to go with the story of the complainant, which is that the other way around, which is she went to start her own business. Somehow her former employer knew that this was a mark she wanted to use, knew she wanted upkeeping.com but couldn't afford it, and went with upkeeping.co. And then the respondent registered upkeeping.com for itself, and put up the thing that really hurt the respondent was the respondent put up a complete copy, I think, essentially, of the complainant's website. I'm sorry, yes, of the complainant's website. Maybe this is the one that may have changed the team pictures to be like other stock photos, or that could be the next case. I'm forgetting. But that was the respondent's downfall, was just putting up a copycat site, because that really, well, and not responding, that really sort of tilted this case in favor of the complainant, because all you have now is, with the facts that are in there, is she got, somehow respondent knew she wanted to use the upkeeping mark, and that she got upkeeping.co because she couldn't afford upkeeping.com. And the respondent went out and, knowing that the complainant was going to use this, and register that site. I think this is also the case, if I'm not mistaken, that, wait, let me just double check. Was this the trademark one where it filed for a trademark? Or is that the other one? Yes, no, it's this one.
Yeah, they both
So,
file a trademark.
yeah.
Yeah.
So the respondent not only got the name, but the respondent filed a trademark application for the upkeeping mark before the complainant did, which I'm sure pissed off the complainant. Complainant filed it shortly after it. The respondent, I think, lied and said that they had been using it since March 2021, or sorry, since January 2021, knowing that the complainant filed for a mark, or that knowing that the complainant didn't start using it or didn't register its company until March that year. So the respondent was a little bit devious. It filed the application first, claiming a first use date that was before the complainant actually registered her company name. And the complainant here was honest and said, I didn't start using it till March. The complainant opposed the respondent's application, and therefore it went to the Trademark Trial and Appeal Board to consider the opposition. That eventually got dismissed due to the fact that the respondent agreed to withdraw its application. And so the mark was, obtained by the complainant. So there's a lot of devious things that went on here. This is one where I'd love to know the real story, but I can definitely see why Alan found in favor of the complainant, especially given the copycat site. If it didn't have the copyright, the exact copy of the site, it would have been a much tougher case, and probably not suitable for the UDRP. What do you think, David?
Yeah, it's a tough case because it should not be suitable for UDRP. So the application was filed based upon 1A, which means actual use, and use in commerce were two different dates. So 1st January 2021, that they started using it, that would probably have been in-state, but in commerce means interstate. And their specimen is a login for upkeeping. It looks like create a user page username, and that's not actual use. So they had to withdraw that first use date, and then it was based on proposed use, so 1B. And the filing date for that was in October 2021, weeks before the complainant filed her trademark application. The complainant did oppose the respondent's trademark application. There was a default, and basically the thing ended, right? Because if the respondent does not respond, you lose in a USPTO opposition. In this case, his email was his response, which didn't give too many facts, but gave enough to say that, yeah, she was an employee. Now, this thing about fraud and creating an email address with her name at upkeeping.com, is that true? I'm not able to verify that. I am seeing that it has MX records for Google. I don't know if there was a catch-all or whatever, but that could have been it. I'm looking at the historical data through security trails, and it's hard to see. But this name was registered a long time ago in 2005. Was it actually sold on DAS? That's a good question. I don't know if that's true or not.
Yeah, I never heard of DAS. You guys familiar with that?
Yeah. DAS is a domain or platform. It's well known amongst Europeans because they don't care about US know your customer stuff. I think it's based in the UK. So they have European rules on money transfers. So like Germans prefer to use DAS as opposed to Afternic.
Has low
So
commissions.
are they affiliated with any registrars, or it's literally its own
I think they
beast?
are. I think they are, Jeff. They've been around for quite a while, and I need to. But I know their marketplace has low commission. I think it's like a 5% commission, and need to. We hear about it as domain investors. We know about it because it's another platform, and we see people report sales off of DAS. I'm assuming, right? There's in this case, if the complainant if the respondent had a more complete and professional answer, the decision, I think, absolutely would have been differently. I think even Alan would have thought, "Man, this is not. There's too much here." Meaning, all the respondent had to say, as you mentioned it, Jeff, is this person worked for me. We had discussed this name and going and doing business as this. And then it would have been seemed less devious, all the dates. I started using it way early because Alan, I think, just didn't believe the respondent. You're just saying too much bullshit and you're not providing any evidence. It was some informal answer, not providing any evidence, doing it the right way to back up these claims that really don't make much sense. But the truth of the matter is there was a relationship prior to upkeeping.co or upkeeping.com being registered. So that already makes me believe this is probably not suitable for a UDRP, but in this case, I think, Alan said it's still within the realm for me, and I don't care about, there's just not having a formal answer from the respondent, and certainly not making it professional and complete. Alan ruled 1, 2, 3 that the complainant met, the burden, met all the different aspects of the case and transferred the domain name. So in this case, I think the respondent certainly had a good, if he would have slowed it down, a good chance of maintaining this name. If he wouldn't have, I just got on Alan's wrong side on this one. But also, it sounds like he lost, if in fact he did buy it, lost $7,500. And the complainant came out smelling good, huh? Didn't want to pay for the name, but ended up with the name anyway. Spent $1,500, and that just really just shows you that in that case, when we first think that a complainant and respondent had worked together before, even if it was like a hosting company working, we always think there's probably more to the story. Let's not decide it here in a UDRP. Let's let them fight it out in court where there's more discovery. We get more answers. That's why we think let them handle it there because there's probably more to this story. But Alan didn't. Alan thought, I'm going to decide it, and the respondent just did such a terrible job of representing themselves. If you're going to answer back informally, might as well just answer formally. I mean, it's not, they'll take any response in a UDRP. There's not like you need, too much of a format to respond. All right, we'll get to our last case. So that was a transfer. So the first one, reboost.com, that was complaint denied. That domain owner got to keep the name, even though there's a company selling Reboost energy drink. This company that was selling the gummies got to keep the name. The panelist said that's legit and actually helped them out by doing research. The second case we just talked about, the upkeeping.com, the complainant wins, had a relationship with the respondent, both in the same business, and ended up convincing the single member panelists there to transfer the name to him. This last dispute was for the domain ADAPTY. 6-letter, sounds like a brandable to me when I first see it. Adapty. Okay. In the old days, that's pretty fanciful, meaning if somebody names their company that and especially if they get any kind of notoriety, that seems like definitely a unique name. We wouldn't, seems like no one else would be allowed to use adapty.com. But now in the days of and today, when we're domain investors, we think that's a brandable. We try to pick names that maybe no one's using, but potentially will use in the future, or it's just catchy, so on. Anyway, Adapty Tech was the complainant in this case versus Terex Chaudhry. It was an individual that works for a company, Apexon, Apexon. Long story short, is the complaint been around since 2019? They offer some subscription. Um, does it a description something platform? I can't even read my writing. Agent, it's not agent. Something, some kind of subscription platform. But they originally were on adapt.io. Okay, so they were on adapt.io. They ended up you have pretty healthy revenue, like 20 million, recurring per year. So they felt like we're well known. We also got a service mark on this name, Adapty, and we've been doing business. We got a trademark since 2019, but a service mark since 2025. The complainant claimed that the respondent acquired the domain as, this is a quote, as a remnant of a former business entity. Bottom line is this company, Apexon, bought this company, Adapty Inc. So there was somebody named Adapty before Adapty Tech, who's the complainant in this case. The respondent bought this company, and with buying the company, they got the domain name and everything, I guess all the other intellectual property, but the product, this Adapty Inc., had some product. Anyway, they ceased using the Adapty brand, Apexon, Apexon. They stopped using the brand. So this complainant said, hey, they stopped using the brand, and there's no reason. They're not known by Adapty, so them owning the .com and not using it, and that really they have no legitimate interest in it. They just happen to pick it up, like he said, as a remnant of a former business, which already makes you think as a domain owner, well, that how are you going to prove that they, acquired it in bad faith? They acquired it as part of this company, and even though they didn't register the name, they acquired it. How are you going to prove they acquired it in bad faith? The respondent did not even reply in this case. So this company that owns this name really at risk here because they didn't respond against all these claims the complainant was making. The panelist, James Bridgman, solo panelist, went ahead and evaluated the case. And David, add in any facts that you want here. I mean, there's a little bit more to the case, but Adapty Tech versus this Terex Chaudhry, who runs Apexon, had the solo panelists tell us about the decision, please.
Well, the later acquired trademarks don't give them rights to pre-existing domain names. So that was the big issue here. And you can't just apply for a trademark, get a registration, and go after one that already exists. So domain transfer was denied. And yeah, it's Pexon is the email address that it went to. So yeah, it's the same entity. There's no problems with this particular domain name. And there should have been no UDRP. It should have been an RDNH. Wasn't RDNH? I don't remember seeing that.
He ruled no RDNH because he had a reason for it, but he did deny the complaint. You're right, but no RDNH. And I don't know if you have any more comments, or Jeff, you do. There was a few things about the non-reply. You always run a risk of having a panelist, make a bad decision.
Yeah.
Go ahead.
Yeah, I mean, again, I decided to read the facts so many damn times, but it what the complainant, I think, because the complainant ruined its own case, right? The complainant essentially was trying to make the argument that yes, this company called Apexon did acquire the rights to the domain name, but this particular respondent is not really Apexon. And I had to read that like 5 times going, what? But, and I'm sure the other panelists had to read it as well many times because the complainant doesn't really submit any proof of that. But I think that's what the complainant's trying to say, because it does admit that, yeah, Pexon did get the rights to this. They're not using it, and I don't think this respondent is a Pexon, but it couldn't show that. Um, and really, and the complainant ruined its own case by it tried to make the argument that, look, not only did it um, does Apexon not have rights to it, I tried to get the rights from them many times and they never responded. But what that shows a panelist is, no, wait a minute, just because the respondent doesn't respond to your offers to buy the name, that doesn't that's actually a bad thing for you. It basically shows that, well, you couldn't get it through negotiation, so now you're going to try it as a plan B. um, that's never a good thing when you put forward evidence that you tried to buy the name, were unsuccessful, and you think that's showing the other side's bad faith. I don't understand the logic that those attorneys use to make that argument, but I've seen it in a couple cases, and it never ends well for the attorney making that argument. Um, but yeah, this is one. I think he said, well, look, when they filed the complaint, they didn't know who the respondent was, and therefore we're not going to find RD&H, which is kind of a weak decision not to find RD&H just because the complainant didn't know at first who the respondent was. The fact is, it did find out who the respondent was, and once it did, it could have amended its complaint or could have dropped its complaint, but it didn't. And so to me, that's still, um, the use of a privacy service in this day and age, uh, number one, is normal, or it's by default, privacy by default. Um, and I don't understand panelists that still find the registrars automatically redacting as showing a registrant's possible bad faith.
Well, you brought up a couple good points I want to bring up, and then we're going to finish this case. But about Jeff saying, yeah, so they bring up we made offers, got no response. Well, that obviously it seems beneficial to the respondent. It shows we weren't targeting. I mean, obviously that, but if they would have responded and said, "Oh, we waited for you to contact us. We thought you would want this name," then you want to bring up, "Hey, we made an offer, and here's how they responded." But to use it the way they did, yeah, it doesn't seem beneficial to their case. And then also about James Bridgman, he denied the complaint, good decision, but didn't want to rule an RD&H. And he also brought, that the complainant said the respondent could not have plausibly been unaware of the complainant at the time of they acquired the name. All right, but what's that got to? I mean, basically, somehow the complainant did appeal to the panelist enough to think, so they didn't abuse the system. They didn't know. At first, they didn't know who they were going after. And like you said, they could have certainly said, oh, now that we know, um, we do want to retract or rescind. We don't want to, cancel our filing. But anyway, so it really agree with both of you that it should have been an RD&H here. But when the respondent didn't reply, respondent was probably smart here. Who knows? That maybe they weren't at Pexon and they just didn't touch it and they got the ruling in their favor. Maybe they could have, it seems like people can F up their own defense sometimes. Sometimes they can mess up. Like in this case, the complainant messed up their own complaint. So who knows? Maybe this worked out exactly, maybe the respondent by not replying really, strategically was a good move. But someday we'll find out why there's so many non-replies, and it must be they're just intimidated by replying to something that they think is a legal issue or a legal matter. Because, like I said, you don't have to. There's no really tight procedure or formal way you need to answer. Of course, you like to address what the complainant is saying, and then you want to supply evidence of anything that you say because your words don't mean much without evidence. But why is there so few responses, especially for even valuable names? When it's a crappy name and it's an obvious infringement, or you're obviously targeting a company and you're putting PPC links and you're trying to make money off somebody else's mark, I understand it. But we see there's just so many non-responses, and I just wonder, are in all the cases, are they aware of it and just you know um, intentionally non-responding? Because it just seems like there's just so many non-responses. I would like to know. I would like to see registrars um, responsible for reaching out to um, domain owners to say, hey, you should have got this from the forum, or you got this from WIPO or some other provider. We just wanted to follow up and say this is a legitimate complaint. Your name is locked, so you can answer this, and also sort of prod a domain owner to say, hey, you might want to answer this. And I think it'd be good all the way around to get to the bottom of a lot of these, what's going on with these domain registrations. All right, that's going to be it for today. We're going to go to Arif. He had some comments on the Ping case, and then comments about ICA. But Arif, it's nice to talk with you. Hope you're having a great year so far. What's up?
Yeah, my last year ended up really badly. All you guys know my 2025 was pretty horrible. Then the weekend after New Year's, I had a really bad fall. My leg, my ankle was just unusable for a while. So I've been pretty much on the couch since, slowly getting better, but it's just a little bit too slow. But anyhow, hopefully 2026 will be much better. I do seem to have had a nice sale right at the beginning of the year, so that's really good. I also had one last year I kind of spilt over, but it was a very small one. But it was one of those ones that I was going to drop, so even better. But to get on, I had a few things, but just on what you just said just now, I just wanted to know, get the the opinion from you guys. Are registrars supposed to respond to like lawyers or whatever it is on behalf of a complainant without going through one of the larger, one of the um, like WIPO or whatever it is, or can they go directly?
So when you respond to a complaint, you are responding to the dispute provider, not to the complainant. So it is going to WIPO or arbitration forum, and ultimately the panelist. Whether you want to send that to the complainant or not, it's your decision. But the panel or the arbitration provider will send it to the complainant, even if the respondent doesn't.
Okay, but my question is basically prior to that point, is a registrar allowed to give your private information to a just like a lawyer, not pretending, but representing a potential future UDRP complainant, but without having started the process?
So that's a much more complicated issue. Um, Most registrars these days will not give out that information unless they find some, illegal activity or counterfeiting. Even then, they may not. But just general cyber squatting or infringement, they require a court order or a UDRP filing.
Interesting. Okay.
They're
Perfect.
trying to get that changed, the IP owners. That's one of the big battles in ICANN. It's an ever-ending battle because that battle's been going on since ICANN was formed. But it is still a battle that IP owners want trademark abuse, or what they call trademark abuse, to be considered domain name abuse. On par with the same thing as phishing, farming, malware. They have not been successful in that, but they keep trying.
Okay. Yeah, no, because I know a situation where that has happened. I won't discuss it because I don't know if people want that talked about, but thanks for that. Second
But there is
thing,
no, just let me clarify. There's no rule that says the registrar can't.
okay.
It's not like ICANN says you can't give it. It's up to each registrar to determine what its own legal obligations are or are not.
Okay, but there is when you have your domain registered privately, there is the expectation that the registrar would not give the person's information without at least some just cause, whether that just cause not be legally defined, but that you'd expect like it not just handed over willy-nilly. Would that be at least a
I mean, certainly if you purchase a privacy service or if they say a privacy service is included, um, yes, but now it's privacy by default
yeah,
without paying. So you got to read the registrar's terms and conditions, but they all have terms and conditions saying that they have the right to disclose it for a whole bunch of reasons. So they give themselves the leeway to do it. Most of the time they don't, but it's up to, like I said, it's up to the registrar.
got it. Okay, thanks. So the other thing I wanted to get back to was the whole the Ping TLD situation, which I found really bizarre because obviously if like I'm not too sure you guys are actually probably the experts of how to reply this, but when a entity plans to makes a bid on a potential new TLD, aren't they supposed to indicate whether it's the intention is to have it public or have it as a private brand?
So back in 2012, there was no such thing as an application for a private brand. That was sort of created after the applications were submitted. Um, so um, you were supposed to indicate what you're going to use it for, but it was not graded, and you could have just said, well, it's a generic GTLD like .com, right? And if you said that, which is I believe what was said in this application for Ping, then that's all the information that's out there. Karsten, the owner of the trademark for Ping for golf, filed what's called a legal rights objection, saying that the any way they use the TLD will be infringing, and the panel said no, um, and found that not to be the case. So at some point between the time in which that dispute was decided and the TLD was delegated, I believe. I have to go through the delegation records, but that's when Karsten must have entered into some deal to purchase or to get it from Radix or whoever applied for it.
Okay, yeah, because I'm just thinking like if I have a brand that includes the word Ping or something like that, and it's nothing to do with golf or I think it's or anything to do with that company in question, like I would there should be I don't know there should be some kind of mechanism where I be allowed to have access to that TLD. I would think, unless originally it was made distinguished as private. It just seems like there's something missing there where it's like there was a little bit of bad faith going on in that if at one point Ping was determined to be generic, right, and that the company did not win their case, well then that TLD in theory it should be open to the world. Now obviously Ping could turn around and go, yeah, we're open to the world, but we're going to charge $1 million for every registration, and it ends up being the same thing. But still, you know what I mean? It just feels like there's something missing there where they took advantage of a loophole to close off access to a potential TLD that could advantage other people. Like there is legitimate use for a .ping, especially in the tech world, where I think people would want to take grab a few of those domains.
Yeah, so in this coming round, if you want to use it as a closed TLD, as a brand TLD, and you actually own a trademark, then you do have to say that in the application. So you will find brand applicants now in this next round specifying why they're doing it. And the other reason is some of the contractual requirements won't apply to you, right? If you're a brand, you don't have an obligation to use every registrar, right? You can pick one because it's for internal use. And why the hell would you want every registrar to be able to sell names when you're just going to probably give it away for free to whoever, right? Um, so in this coming round, there will be that disclosure in the application.
And will there be a period of time where I guess like trademarks, the public can contest the the basically the closeness of the usage?
So there is a public comment period when all the applications are revealed. And if someone from the public wants to file some comments saying, we know, I'm trying to think of a brand that doesn't that exists, but it's not a TLD. Let's say Time Magazine. .time isn't a TLD. I don't know if it is or isn't, but it might be. Let's say it wasn't, and Time Magazine applies to .time and wants it to be a brand TLD. In theory, the public can make a comment on it, but as long as the brand can show it's got a trademark and it's not, Time is not a generic, or that Time is a trademark, and it's not going to be used in its generic sense, then you're allowed to use it as a brand and close it off to everyone.
Wow, that's there's something, I don't know. Like I know it's tough to set these rules because you're never gonna have the perfect balance, right? Because it just doesn't really exist when it comes to trademarks. It's never black and white. And not that these are trademarks, but it mirrors them. But it just seems like time should not be allowed to have those rights to block it off completely.
So it does say in the guidebook that if you're applying for a word or a string that is also a category of goods or services, now time wouldn't be, but books, right, which Amazon initially applied for that as a closed TLD, that can't be a closed TLD because that's a generic category of goods and services. Time, it's really hard to argue that that's a category of goods and services, but books, music, tunes, a whole bunch of things that were applied for in 2012. And I'm sure if like crypto is applied for, or a bunch of other terms that people are, or GPT, right? If ChatGPT applied for ChatGPT, that would be one thing. If ChatGPT applied for .gpt and wants to have it closed, that's a whole other situation where there could be objections that would be taken much more seriously than a dictionary word that's not really a category of goods or services. Does that make sense?
Yeah, no, definitely, it definitely does. It'll be interesting to see what happens. And is that objection period, is that like a very short term, like a 3 weeks type of thing, and then once it's done forever, or?
So that period of time is 90 days once the applications are revealed, to file comments or an objection. And it is the last time you could file an objection, unless, of course, let's say Time Magazine got, no, not Time Magazine. Let's say, let's say they got .time as a brand, but then they start using it in its generic sense. Then at that point in time, that would be, you'd have to get ICANN to enforce their agreement. But in theory, that would be a violation of the agreement, the registry agreement.
Yeah. Okay. And let's say they do use it generically. Are they able to like say, okay, well, we're open to everybody, but like at $100,000 per registration, or does it have to be reasonable? Because it doesn't seem like there's a cutoff or a line where it's like considered reasonable or not.
And that's the rub, right? So you've now clued in onto what some of these registries or brands have done. So it essentially becomes a closed off TLD because the price is ridiculous for anyone to pay. Technically, there's nothing barring that, assume as long as the price for everyone for those names is the same. Now you're going to say, but the brand is just paying itself for the name, so it's not really,
Yeah.
but that's, there's always ways to game the system.
Oh well. Okay.
But look at it mostly like most brands aren't going to go that far to actually keep a closed registry for themselves for a generic word. Most brands would rather put their money into their brand name as opposed to a dot books or something, um, and
Yeah.
make it subject to everyone having to register it.
And I think actually probably this would probably happen more often or not, just out of maybe not laziness, but out of just like they can't be bothered to do the work of actually making some agreements with registrars and whatever it is, right? Like I think that wasn't their intent. They might not even have somebody in the business who is qualified to do such things. So it's kind yeah. So interesting situation.
Well, the other thing that could happen is, and it has happened, so Google initially applied for dot search as a closed brand TLD. They were told they can't do that, so it's actually an open TLD, but they've never launched it.
Yeah. And
That's
that's the thing.
okay.
But at some point, can somebody say they're acting in bad faith by not making available what they promised to make available, and let's either reopen this to a new round of applications or claw back their ownership of it, or maybe not ownership is the word, but their own. Well, I guess ownership is what it is with MGTLDs, but you know what I mean.
Yeah, they're well, it's a license. It's considered a license to be the registry for a 10-year period with automatic renewals. Um, so let's see, dot search was granted. Let me see, ICANN list of TLDs. Um, Google still has dot search. They've never launched it. I don't ever see plans for them actually launching it. I'm just trying to see now if they renewed their agreement. But there is no grounds to not renew an agreement or to terminate an agreement for when I say non-use, technically it is being used. If you go to nic.search, nic.search, you'll see their ICANN required page that they're required to have, and that's considered enough use. So there is nothing that says you have to, nothing that defines what use of the registry actually is. Yeah, so there's loopholes, and Google's strategy may now just be, look, I know I'm not allowed to use it as a closed TLD. I don't really want to run an open TLD because I don't want all my competitors to be in that
Yeah.
TLD. So I'm just not gonna do anything with it. And essentially that's what they've done. And there's not really any much that anyone could do. Um,
So
so
this
the
seems to go like completely against the mission of what ICANN is supposed to be about, right? It's supposed to be about making things more accessible and whatnot. I mean, again, like I understand there's loopholes and they can't do everything all the time and they can't please everybody all the time, but this just seems like it's a very flagrant open loophole that at some point they need to address.
Because
Yeah, I mean that's recognized, I think, but yeah, so dot search was the agreement was signed June 9th, 2016. So it's coming up for renewal this year. And those renewals are really just automatically granted. Um, yeah, it's interesting that some of these brands now are coming up and they've never used them. It doesn't really matter, like nobody cares, let's say, about, whether dot I'm trying to think of someone that hasn't withdrawn that's not really using it. Um,
Well, no, I think KPMG actually used it for a while, and then they kind of stopped
yeah,
using it. But nobody's gonna want that domain, like
right.
KPMG, right? Yeah. So
But dot search,
yeah,
certainly, there were a lot of applicants for that. Google ended up getting it. They were not allowed to use it as a closed TLD. They had to put in some parts to the agreement not to say that it would be open. but they never had to say or actually launch it.
Well, let me say this. So we know like what Arif's getting at, and what we're going to do, Jeff and I, we're going to have a room that's just on GTLDs, and we'll probably do. We talked about it. Now it's really time to do it. Arif, a lot of your questions certainly want to bring those up again because we'll have a new room, GTLDs, sort of like how the ICA, and Arif, I'll let you make your comment about ICA right before we shut down, is when they have a seminar, a webinar about GTLDs. Well, I want to do that. We'll have Jeff, myself, and maybe a couple others that want to, be on a panel, but really just answer the most likely questions. But these are interesting questions because Arif, right, it would have to be some groundbreaking lawsuit, really, to say, hey, so the spirit of the whole thing was they're supposed to have these extensions to offer to the public. ICANN was clear that they can't keep it private, so it needs to be offered. They've had it 10 years. It's not being offered. You can bet they're probably going to renew it, and I don't know what that fee is. We're not going to talk about it because we'll answer all these questions in a specific room on GTLDs because there's so many questions. And Eric, if you have 3 or 4 great ones right there that we want to revisit and answer those, and then I got dozens that I asked Jeff in private that we'll do in public because now that the guidebook's out and Jeff brought up some great things. In 2012, there was no rule about it, but now if you're going to use it as your brand or you're going to use it privately, you do need to disclose that. And then we're already talking about the loopholes when they decide not to launch it if they say they're going to use it. And then final I'll say about what happens, like you said, .time, and then somebody decides, or like they did with .ping, to buy it from the person who said we will keep it public, and then a company buys it because that's our brand name now, and they don't want to legally can that new owner do to keep it private if that's what they bought it for. Okay, so we will have a room, and we'll schedule that after ICA, as a matter of fact. We'll try to do it maybe early February, just a room just on GTLDs, because it is time, and there's a lot of companies out there that are, now I'm hearing about that .anime, for example. From what I heard, that sounds like Unstoppable's going after it, and so is D3. But I mean, we're going to talk about people going public with extensions that they plan on applying for. All right, Arif, what's your final comment you want to make on ICA?
Well, yeah. So as I mentioned before, I won't be there for various reasons, some of which we won't get into. But as you guys know, 2 years ago, I did stand up and I mentioned that, we should, as a group, we should look into exploring the scope of the ICA and whatnot. And I wasn't very vocal about it 2 years ago. That was my first time at a conference, whatever it is. And then last year, after there was no real, movement in that over the previous year, I stood up with actually Jeff behind me and was a little bit more vocal about it, and originally was shut down by the board, but then they kind of approached me and go, yeah, no, you know what, you're kind of right, and we're going to look into it. And then a month or two after that, Todd, I think, as you know, I was told that we would be discussing it, that they would be going ahead with having, an open discussion about, what the scope of the ICA should be. For me personally, I don't want it to be too specific on any one company or any one thing, but for me, my biggest concerns I think we should explore as a group is, more of how some companies have very large, almost monopolistic market shares in certain aspects of the industry, and whether or not they use it to influence other aspects of the industry is what I think is something that we should look at. Now, again, I'm not making accusations on any one company and whatever it is. I think you guys can read between the lines and where I think there might be issues. And again, I'm not saying it is or isn't. I'm saying that as the ICA, as the institution or the association that's supposed to look at various aspects of the industry, well, that's the question: is that, do we look at various aspects of the industry, or is it just what Zach does? And what Zach does, with the UDRP changes and whatnot, and going to these meetings, I think is crucial. Like, I wouldn't want to stop that by any means. However, I do think if we want to be the industry association, there are other things, not just the things I want to look at, but other aspects of the industry that do need, looking at, especially because we're a size of industry we're not tiny, but we certainly aren't at a size where the government's going to come and step in without, major people screaming, yelling, and whatever it is, because it's just we're too small for most people to care.
So RF, can you come up with a couple, and you can email me privately too, a couple examples of issues that you think should be discussed, but we may be avoiding because of some of the members of the ICA? Because that's going to be important to say these issues came up in 2025 and we didn't weigh in at all.
Yeah, okay. One of the reasons, like, I'm really disappointed in that. Again, like, I don't want to bash the ICA too much because they do a lot of good. Again, I think Zach going to these ICANN meetings and pushing back on the lawyers that represent the IP side of things is very important, crucial, in fact. But again, like, as we talked about last year, there are other things, and as you said, like, the board members. I don't even think it should be about the board members. Like, for me, the irony is, I think VeriSign could be a part of the ICA. And as you stipulated, when it comes to things that do implicate them, they should obviously be set aside. They should step aside when it's something that's, pending to them. Same thing, again, like, obviously I do have concerns with, I don't want to say the name, but, let's say, GoDaddy, they have very large market share in many aspects in the industry. And a lot of their agreements are just private, right? And so what aspects of the clout of certain aspects are they using to take a competitive advantage away from other potential competition in other aspects of the industry, right? It's just I don't know, like, it's I'm not saying they're doing it, but I'm saying, like, these are things we should be discussing and be aware of and explore. But
Right.
again,
Well, that's why I'm saying if you come up with, instead of a company, but some issue that's common across domain industry players, the issue itself, like whether it's, I don't know, commissions, whether it's, maybe not, that's pretty sensitive to discuss for an antitrust reasons, but maybe it's certain improvements that need to be made for domain investors. Um, that's what we need to kind of bring into the conversation.
Yeah, and the thing is that, like, after, as you know, you were right beside me, but when I first brought it up, and I was standing up or whatever it was, my phone was ringing from back home with the craziness that
Yeah.
was my family stuff. I was a little bit all over the place, but then they shut me down. Like, they really, literally shut me down. But again, afterwards they go, okay, well, we kind of think you're not wrong. We're open to talking about it. And then they came back to me with a month or two later, and they said, this is something we will open up and we will explore this as a group, like, not just private, whatever it was, but, like, we should open it as the ICA, members of the ICA. For me, my vision was, yeah, we'll have a few times a year, we'll get together on a Zoom call, whoever cares about this kind of stuff, we'll debate it openly, and over time we'll go, okay, this is something we should cover or not, and not be a one-time thing. It should be like to me, it should be something that's open-ended and we revisit regularly, right? It's like, but again, in the last year, radio silence since I was told it would happen. Now, again, what their actual vision of what was going to happen would be, I don't know. What they meant by we're gonna go forward on this, I don't know exactly what the mechanisms they were going to do was. But again, I thought it'd be like an open forum type of thing. We have open discussions and debates, and just healthy discussion. And if some of these companies were there to push back, fine. Like, I'm okay with that, right? Again, like, for me, I'm one of the few people who thinks VeriSign should be a part of the ICA, right? Because again, we can have those discussions and they can answer us, and and again, when it's
Let me just
appropriate.
say, because we're closing this down, I got shit to do. I mean, damn, that now I can be myself again. It's fucking 2026. Well, first of all,
Welcome back,
everything's
Todd.
got to be specific too. So VeriSign doesn't want to be a member. Neither does Rick Schwartz. So there's going to get some people who don't want to be members, and then sure you can try to make it attractive for them. Whether it's individual domain investors or companies, but like Jeff said, got to be specific. What do you want? A code of conduct for registrars or for registries, or
Well, Todd, yeah, so one thing I asked for last year, and I haven't seen any update, is there needs to be a conflict of interest policy.
Yeah.
All boards and organizations have a conflict of interest policy, and that in general covers what things you must recuse yourselves on. Um, that needs to happen. Um, and they said, I think that was the thing they kind of agreed they would do, but that they haven't done that yet.
Yeah, well, in other specifics, like you were talking about on um, disclaimers on websites in terms of service things. No, I like that. That's like you need to be specific. And when Eric's talking about the
So,
scope of the
but
ICA, well, what do you
that's what I'm
think the
saying.
scope of the
You're,
ICA should be? Give an
you're not.
example, even though you
But
know.
here's the thing: is that you're not wrong. What I'm talking about is exactly on that broader level. There should be a mechanism where people should be allowed to come in with an issue, a specific issue that you're talking about, and there should be a mechanism in place where okay, it's presented, and then we look at it as a group. We can discuss it, debate it. Is this something we want to look at? Is this something in our interest or not? And then we move on one way or the other. But for me, it's not about the individual things just yet because we don't even have a mechanism to present those things.
Well, you can
Right? Like,
contact any board member. You can contact Zach and say, but what you want it to be on the website. Click here if you have an issue with the industry. I don't know. It doesn't matter. Bottom line is you can contact Zach directly. You can contact any of the board members, and you know them, Braden from JT to I mean Jay. You can contact Nat. Just contact the board member. Say I want to address this. And when is our next? I mean, basically, you can force the issues. You know, I mean, this is such a small organization. You can say, hey, listen, I want to talk about this at the next meetup. Hey, I can't be at the next meetup. When is there going to be an online forum that we can do that? In Eris, I know you've said, when is there going to be? But I guess the thing is, when it comes to, being specific, I think what would help, like in some of the issues, and I'm just guessing that you may have with, say, whether it's registrars or registries or some of the big companies, you'd want to get a hold of, say, if they have the issue thinking with GoDaddy and sometimes their dominance in the marketplace, what is, whether it's Namebright, Namecheap, and I don't even know, I never see Namecheap around. I know Dynadot's going to be, I got an email from them saying 3 of our people are going to be at the ICA. I'd say Todd is not going to be there. Todd's probably already like, I'm over it. I work for a living. But I mean, because sometimes I'm wondering, these other registrars, how do they feel, and where do they on an open forum, where do they say, hey, here's how we believe GoDaddy is limiting or monopolizing or doing something in the business that we've had, because then you have like, geez, Arif, you might have an issue that you think, and then if Namebright is behind you saying, yes, here's what we've experienced and how it's affected our business by them doing that. But I just think it needs, has to be specific things like, hey, people, yeah, what's weird, GoDaddy sponsors the dinner. And of course, Paul Nix is no longer around. We're going to miss Paul at the meetings. Wonder who's going to be, stepping in for him at the meeting. I know they are.
Policy,
Yeah.
James Bladell,
James.
policy, a
Yeah.
policy person. So
Yeah.
he's not a business person, but it'll be interesting to see what James can or cannot say.
Well, I'm going to report back. Arif, here's everything we went over, but I'll talk with you prior. Next Tuesday, we got a domain name law show. The ICA event starts next Wednesday. Thursday and Friday are the main days. I think Thursday, Friday, Saturday. Well, so if you can, everybody in the room, thanks for being here. Next Tuesday, we'll have a domain name law show. We're going to have a special show on GTLDs. We'll schedule that in the end of the month or maybe early February. Definitely be around this Thursday, 10 a.m. Pacific. It's 1 p.m. Eastern. Josh and I are doing our first show, DNX show for 2026. Got so many topics. I know some of our friends sold some names like Siger sold Dragonfly, and we saw MetaWatch was sold for 290 grand, and just all sorts of sales going on. We're going to talk about that, but obviously tons of news. Just so much has gone on, and Josh, of course, wealth and knowledge, and he's posting more than ever, but really has a lot of, as they say, alpha, a lot of insights to share. So we'll see you Thursday morning on the DNX show. It's Thursday morning for me, 1 p.m. Eastern for a lot of you, around the place. But, and then of course, domain name law Tuesdays, DNX show on Thursdays, and we're going to have a big report back and maybe even during the ICA, because Josh and I are going to be there not this Thursday, of course, be with us here online, but next Thursday we're going to be in Vegas. So worst case is, Arif, I may need you a little bit then, to when we do a spaces, see what Josh and I are doing, actually when we're there. But everybody, thanks for joining us. Arif, it's great to talk to you too. But thank you, David, for being patient. Hope you didn't, tear up some papers. David likes to be punctual too. We went over today. I'm glad everybody joined us. Thanks a lot.
That's what we're to the end. Really, guys, thanks for being here. I'm happy you guys are back. This room is really very, very informative, and it's really an asset to the industry. So
we're going to be on point the rest of the year, meaning every Tuesday, domain name industry legal news and UDRP reviews, and we're going to have some guests too. So when I'm at the ICA meetup, a few guests, not just other attorneys, but some business owners and operators. All right, thanks a lot, you guys. Have a great rest of your day wherever you're at. Take care. See you next week, and see you this Thursday. Be sure to be there when Josh and I do the DNX show. Take care.